Welcome to Crime in Court. This is an update in the Menendez brothers trial. On my channel, we have been rewatching the trial. We are almost complete. We have finally made it to the closing arguments, which is kind of fitting that this announcement is coming right at the end of us watching the trial. So let's actually listen. A couple weeks ago, the DA of Los Angeles, George Gascon, came forward and made an announcement and said that he was going to be reevaluating the Menendez brothers case. He said he believed that there was abuse that had happened in that home. He believed the boys and their many, many instances and evidence of physical, emotional, intimate types of ABUSC that were going on in that home. So he believes them. He said he was going to reevaluate, and now he has a decision that he has come to. So we're going to watch his press conference that just took place on Thursday of last week, and then we are going to go over his memo to the judge. Well, first we're going to go over the process and what happens next. Could the boys be released into society and finally be free? We will look at what the process is, and then we will actually look at some of the memo that George Gascon has written to recommend the resentencing of cat's out of the bag, the resentencing of Erik and Lyle Menendez. So let's begin. Here is the press conference from Thursday afternoon, George Gascon, DA, Los Angeles.
Hey, good afternoon, everyone. And before I begin speaking, I want to also introduce some other people that are here with me, and hope I'm pronouncing the names right because I've seen handwritten part of it. But I have Ana Maria Barat, Jose Menendez, Jose Menendez, and niece Karen Vandermolen, and Katie's niece. They're all here with us. Also with us here is Brock Lunsford. He's the assistant head deputy for the post litigation conviction unit, and Nancy Cervier, who is the Deputy District Attorney in charge of the resentencing unit. Let me begin by telling you that this is a case where we've had many people in this office spend a great deal of time reviewing the case. I have to tell you unequivocally that we don't have a universal agreement. There are people in the office that strongly believe that the Menendez brothers should stay in prison the rest of their life, and they do not believe that they were molested. And there are people in the office that strongly believe that they should be released immediately and that they were in fact molested. I have to tell you that after a very careful review of all the arguments that were made for people on both sides of this equation, I came to a place where I believe that under the law, resentencing is appropriate, and I am going to recommend that to a court tomorrow.
I kind of skipped there. He said recommending resentencing is appropriate, and he's going to recommend that to the court tomorrow. So this doesn't mean that it's an automatic. They are resentenced. So I know, like, we're all really excited that this is happening, but we need to just chill out a second and not get our hopes up, because at this point it is only a recommendation to the judge, who then has to review and decide to go up against or to make a recommendation to the parole board. So there's still some more steps involved, but I just wanted to let you know, don't get your hopes up too much, even though it's really exciting that he wants to resentence them.
What that means in this particular case is that we're going to recommend to the court that the life without the possibility of parole be removed, and that they will be sentenced for murder, which, because there are two murders involved, that will be 50 years to life. However, because of their age, under the law, since they were under 26 years of age at the time that these crimes occurred, they will be eligible for parole immediately.
Because of their age, because they've been incarcerated since the time of before they were 26 years old. They were incarcerated under the age of 26, both of them. That now they would be up for parole immediately because of the fact that they were so young when the crimes occurred. And this, I believe, I don't know if this is a new law or it's always been the law in California and they just didn't abide by it back then or what, or if it's, something that has been, retroactive, now that it's come into play and if this new law, they can go retroactively and release people who were sentenced at the age of under 26 because honestly, your brain does not fully develop until your mid to late 20s. So to say that these boys were adults, even though legally they were, it's a stretch because of the mental, physical abuse that they had gone through. Their minds weren't, I don't think, fully, 21 years old and 18 years old. They were still children, in my opinion, like mentally. Um, just because of everything that had happened to them. Not to say that they're not, mature, lovely adults, but at the same time, their brains aren't fully developed. So you can still be a good, nice adult at 22, but your brain just doesn't think the same as a 32-year-old or a 52-year-old. And you can't deny it. It's science. Anyways, sorry. Let's go on.
The teams that have worked on this, on the resentencing side of it, have spent literally probably hundreds of hours by now looking at this case. These cases were originally presented on the habeas side of it, which I'll explain in a moment what that is, last year, and then the request for a prosecutor-initiated resentencing occurred earlier this year. And there have been people in this office working in these cases from the very beginning, as well as many other cases that we have. The reason why I'm here today and why I came in front of all of you about 10 days ago is because there was a more recent documentary about the case that again brought a tremendous amount of public attention. And we know there have been other documentaries, so this is not the first, this is a more recent one. And frankly, our office got flooded with requests for information. And even though this case was already scheduled to be heard in late November, I decided to move this forward because, quite frankly, we did not have enough resources to handle all the requests. And one of the things that I thrive to do in this office is to be very transparent in everything that we do. In this case, we review the prison files. And you have to understand that the way the process works, when you're talking about a resentencing under the law, it really focuses not necessarily on what the original crimes were, but it focuses on, has the person been rehabilitated, number one, and number two, can they be released safely into the community? Under that rubric, since I've been in office, we have resentenced over 300 people, including 28 for murder. Only 4 have reoffended. If that was a regular recidivism rate in this country, we would be the safest nation in the world, but we know that it's not. In fact, somewhere between 40 and 50% of the people that go to prison reoffend and get rearrested. And that's why we have so many problems. However, when you look at the case of the Menendez brothers, you see 2 very young people, one was 19 and the other was 21, when they committed this horrible acts. And I want to underline, they were horrible acts. There is no excuse for murder. And I will never imply that what we're doing here is to excuse that behavior, because even if you get abused, the right path is to call the police, seek help. But I understand also how sometimes people get desperate. We often see women, for instance, that have been battered for years, and sometimes they will murder their abuser out of desperation. And I do believe that the brothers were subjected to a tremendous amount of dysfunction in the home and molestation. But they went to prison for life without the possibility of parole, which meant that certainly under the law at that time, they had no hopes of ever getting out. They could have done what many other people do, which is basically said, you know what, I'm here for the rest of my life, so I'm going to do whatever. I'm going to misbehave, I'm going to join gangs, I'm going to live the life of the prison. But they never did that. To the contrary, even though they didn't think that they would ever be let free, they engaged in a different journey. A journey of redemption and a journey of rehabilitation.
And we're going to see some of that in the memo. They go through, Erik and Lyle both have created programs, rehabilitation programs, and workshops and things that meditation classes and whatnot, so that prisoners can rehabilitate and not just sit and rot away in prison. So,
And often the people that begin their journey of rehabilitation and redemption in prison is often very internal. And what they do, and one of our lawyers pointed out this today, is usually the path is people try to further their education, do things for self-improvement, which the brothers have done, by the way. But it's more unique, or more less usual, I guess, when people not only do that, but they also begin to engage in ways to make life for others better. And in this case, the brothers have been doing so for a very long time, creating groups to deal with how to address untreated trauma, creating groups to deal with other inmates that have physical disabilities and may be treated differently. Even in one case, Lyle negotiating for other inmates as to the conditions that they live under during prison.
they're very smart boys. They've dedicated their lives to others in prison. So, just let you know that.
Now this was done by two young people, now they're not as young, they had no hopes of ever getting out of prison. They have been in prison for nearly 35 years. I believe that they have paid their debt to society, and the system provides a vehicle for their case to be reviewed by a parole board, and if the parole concurs with my assessment, and it will be their decision, they will be released accordingly. I must underline, however, this case will be filed in court tomorrow. The final decision will be made by the judge. Court has to agree with my conclusion that they deserve to be resentenced. It is very possible that there may be members of this office that will be present in court opposing their resentencing. And they have a right to do so. And we encourage those that disagree with us to speak, and the court is the appropriate place to do it. We certainly feel we're very sure not only that the brothers have rehabilitated and that they will be safe to be reintegrated in our society, but that they have paid their dues, not only for the crimes that they committed, but because of all the other things they have done to improve the life of so many others. So, again, we will be filing for resentencing tomorrow. We're seeking that they would be sentenced to life with the possibility of parole, as opposed to life without the possibility of parole, which is they currently have. That means that they would have 50 years to life because there were two murders. But because of the age upon which they were convicted, under 26, under current law, that means they're eligible for youthful parole. I think there is also important to have some introspection today, because I think that often, for cultural reasons, we don't believe victims of sexual assault, whether they're women or whether they're men. We saw in our first trial, which, by the way, they were tried twice. The first trial hung. I mean, the jury could not come to a conclusion, and in fact, about half of the jury wanted to convict them of manslaughter, which, if that were have been the case, they would have been off prison a long time ago.
Yep.
And then there was a second trial, and then they were convicted of murder with special circumstances, which led to the life without the possibility of parole.
I think they probably would have got like 15 to 20 years if they got manslaughter. So they would have been out probably about 15 years ago, I think. If anybody knows for sure, you can correct me, but I think it would have been a lot less, obviously.
But it's salient to understand that our own implicit and sometimes explicit bias around sexual abuse and sexual assault often leads us to severe injustices in our community. And I want to speak to those that are victims of sexual assault now, whether you're a man or a woman. Know that we're here for you. If you're a victim of sexual assault in this community, and by that we're talking about LA County, not just LA City, you can come for help. Whether you're prepared to prosecute or not, we will be here for you. We have services for you. And if you're prepared to move forward with the prosecution, we will evaluate it as we do any other case. And if we believe that the evidence is there to present a credible case in front of a jury that can be proven beyond a reasonable doubt, we would proceed accordingly. You do not have to.
I want to point out it's not just LA County, but whatever county you live in, go to your local courthouse, and they usually have some kind of services. They can provide you services that they don't necessarily, like, even if you don't want to file charges or get a restraining order or anything like that, there's other services they might be able to help you find shelter if you need to escape the person that you're with, just FYI.
To suffer alone. You don't have to keep it to yourself, and help is here unconditionally. I'm going to say a few words in Spanish because I know there's tremendous amount of interest from the Spanish media, and I know that there are going to be other speakers today, and then we're going to open it up for questions. Primero que nada, quiero dar las gracias a todos por estar aquí hoy. Cuando sucede. La razón por la que nosotros estamos buscando que cosas para mejorar su vida, y creo que esta petición es.
All right, sorry, I'm trying to get through it. Here we
The
go.
DA's decision reflects the truth that is hidden for so long, and I am grateful. District Attorney
Let's get back.
Maria Baralt, and I'm the
Hablen y después
Family
podemos
member.
tomar sus preguntas.
This is a family member, so good thing I.
Ana Maria, you're going to talk next? Okay.
Good afternoon. My name is Ana Maria Baralt, and I'm the niece of Jose Menendez. Erik and Menendez are my cousins. I would also like to acknowledge the other family members here, some standing, some seated. Joan Vandermolen is here, Kitty's sister, as well as Diane Vandermolen Hernandez, Kitty's niece. Thank you for joining me, everyone. Today is a day filled with hope for our family. We are here because District Attorney Gascon has taken a brave and necessary step forward by recommending a resentencing for Lyle and Erik. The DA's decision reflects the truth that is hidden for so long, and I am grateful for his leadership in making this choice. We stand united in
Why the hell did it take so long? Why does it take so long to get justice in this country? I don't understand.
our hope and gratitude. Together we can make sure that Erik and Lyle receive the justice they deserve and finally come home. Thank you to District Attorney George Gascon for his courage and leadership. This step gives us all hope that the truth will finally be heard and that Lyle and Erik can begin to heal from the trauma of their past. Thank you so much for your time.
Thank you, Ana Maria.
Yeah.
Jose Menendez is going to say a few words.
This is a niece of Kitty Menendez, Joan Vandermolen.
Yeah.
Hi, thank you for coming. We are here today because District Attorney Gascon has taken a brave and compassionate step forward by recommending resentencing for my cousins, Erik and Lyle, and we wish to offer our deepest gratitude to DA Gascon. This decision is not just a legal matter. It is a recognition of the abuse my cousins endured, and we are grateful for the DA's leadership in putting justice over politics. We know this wasn't an easy decision, but is the right one. This is about truth, justice, and healing. It is time for Lyle and Erik to come home. And I ask all of you to join us in this fight for justice. We stand united in our hope and in our gratitude. Together we can make sure that Erik and Lyle receive the justice they deserve and finally come home. Thank you again to District Attorney George Gascon for his courage and leadership. This step gives us all hope that truth will finally be heard and Erik and Lyle can begin to heal from the horrors of their past. We hope this will also shed light and increase awareness and help others who have been victimized by sexual violence. Thank you all so much for being here today. We are grateful for everyone's support.
Is there anyone else speaking?
No, that's it.
Okay. Okay, and I apologize. reading notes here and I'm trying to understand all the notes. Yes, ma'am.
Can you explain, so you go tomorrow, you file a case for resentencing, then what happens after? Are the brothers going to be there tomorrow, and when is the role of the parole board going to come in?
Right, and you know what? I'm going to actually have the people that are handling the case walk you through all of it. The brothers will not be there tomorrow. The role of parole board comes later, but Nancy, why don't you walk everybody through?
Okay.
Yeah. Walk them over there.
So what we'll do is we'll file our.
Say your name and your title.
My name is Nancy Thaberge. I'm the deputy in charge of the resentencing unit. This is Brock Lunsford, assistant head deputy of the post-conviction litigation division. So what will happen is tomorrow we will file the actual petition requesting resentencing with the legal arguments and accompanying exhibits as to why we think it's appropriate. It's just a filing. No one's going to physically be in the courtroom. From there, we'll also serve the defense with our motion and our paperwork so that they'll have their copies. And from there, we will coordinate with the defense to set up a court date with the court so that the petition can be heard. Now, whether or not that's a setting or a hearing will be decided between us and the defense and the court once everybody gets an idea of what we've filed. Then from there at the hearing, the defense can either decide to have the defendants, the Menendez brothers, physically brought into court. They can ask that the individuals appear by video or audio WebEx, a kind of a Zoom participation, which we all kind of adapted to because of COVID. And then from there, we will do the hearing and submit all the written and legal and oral arguments and any evidence that needs to be admitted at the time, and then the court will rule at that point. But we don't have that court date yet because we're just starting the process tomorrow. But it's our intention to have that go forward before the habeas, because if the judge grants it, that may impact the defense's decision to proceed on the habeas. So we're gonna try it just as a matter of economy of time to stack it one before the other.
Now, have the brothers found out about this?
There's a resentencing recommendation and a recommendation to vacate, or they have a habeas corpus petition to vacate. The boys do. So it's two separate things going on. The resentencing, which is being recommended by the DA's office, and then the boys' brief to vacate their sentence or get a new trial based on new evidence. So that's a separate issue.
In real time, or were they told about this beforehand, or what was their reaction?
No, this
No,
was.
this is actually the family was only invited to come. They were not aware what the final decision was until a few minutes ago. The brothers may be actually seeing you guys on TV or social media, but no one knew other than a very small number of people in this office. And by the way, I should tell you that actually the final decision was just made about an hour ago.
Oh wow.
Right. Then it goes back to the prison system, and then the parole system takes over that. That's correct.
Would there be a parole or probationary period? Would they have to live in a halfway house, or simply be released if they're allowed to be released?
You know, those are really completely entirely up to the parole board. Please, we'll try.
What was the factor that made the final decision? You said the final decision was just made. Was it the letter? Was it the Menudo confession? What was it that put you over the top to make?
No, what it was is I was evaluating the arguments that were being made within my office, both pro and against the release.
Can I ask you?
Hold on, I had it.
Calls from
Yeah.
people that
I'm, you have made resentencing a cornerstone of your tenure as district attorney here in Los Angeles. There are some people who have accused you of using this very, very highly publicized, clearly case to use it for politics, given how close we are to the election. What's your response to people who have been making that claim?
There's nothing political about this. We have resentenced over 300 people, including 28 for murder, and we will continue to resentence people in the future. And that's all I can tell you.
But the question, but
Yes, sir.
It just happens to be the timing just happens to be right before an election, and it happens to be one of the biggest high profile cases in California.
Excuse me, please. You're interrupting.
everyone's interrupted. I'm just wondering how you're bid for re-election.
Yes, please. Yes.
Could the brothers be home by Thanksgiving?
I don't know the answer to that.
Why did you decide not to go with the reduced voluntary manslaughter?
That was part of the process that I was still going through up until a couple hours ago. I don't believe that a manslaughter would have been the appropriate charge given the premeditation that was involved in the murders. I believe that these were clearly murders that were premeditated. Now, the motivation, that's where, difference of opinion come up, but I don't think it would be appropriate to go all the way down to manslaughter. Yes, ma'am.
Is your bid for re-election?
Would you please stop? I am not going to talk about re-election, okay?
Okay. So
Do you want to talk to re-election? Go outside. We'll talk later. Please.
It's a fair question. No, it's not. It is a
I'm sorry, you're interrupting, sir. Please. Pues depende, como estaba explicando la abogada
They are speaking.
la donde se opone también la Corte va.
Sorry, I don't know.
Yes, because we're going to make a decision one way or the other. It's just a question of what the decision was going to
Just
be.
giving
Yes.
you a timeline. If you are no longer in office, what happens to this case? Could a potential successor undo what you're about to file?
I don't think so. Once it's filed, it's filed. It's up to the court to take it from there.
You mentioned
Yes, I'm sorry.
Good.
Parole situation, obviously that policy, there's a concept of years ago, since you're obviously supporting the push for release here. How would that work with people from post-litigation, resentencing, they don't put a bunch of arguments for their release? Or that
No. We have a policy that we only send victim services advocate if the victim or the victim's family wants that support. We don't send lawyers to our parole boards to relitigate a case. The parole board is fully aware of what the initial crime was, the crime that led to the conviction. Their work is primarily to evaluate whether they're rehabilitated and safe to be released, and that will be the way here.
Can you break down the timeline for us? Can we expect a hearing by the end of the year? We might-
Nancy, we don't know.
I'm hoping to get it on calendar, depending on the defense preparedness. I'd like to see it go to hearing probably within the next 30 to 45 days at the most. There's not much to argue. Because we're kind of collective.
Okay, there's one more question, please, but related to the case, not to elections. If you want to talk about elections, we'll do that.
Related to the case.
Yes, sir.
What would you like to say right now to Erik and Lyle Menendez?
What we like to say to them, and it's we, because it's not I made the final decision, obviously, but we have a whole team that worked on it. We have a family here that wants to be reunited, is that we appreciate what they did while they were in prison. While I disapprove of the way they handle their abuse, we hope that they not only have learned, which appears that they have, but that if they get reintegrated into our community, that they continue to do public good. Thank you so much, everyone.
All right. So that was the press conference. They are going to be they're going to be recommended for resentencing. So what does that mean? Let's take another look at, they kind of explained it, but let's read this article here from the LA Times regarding the brothers and this resentencing. So will the Menendez brothers be set free? How the parole board, the governor, and a new DA could change things. So let's see. Los Angeles County District Attorney George Gascon's blockbuster announcement that he will seek to have Erik and Lyle Menendez resentenced for their parents' brutal homicides marked the first time that the brothers ever have had hope of leaving the prison since their convictions nearly 30 years ago. They've been sentenced to life in prison. Almost, it was actually 35 years ago that they've been incarcerated, but remember they were in prison during the mistrial and then they had to wait another couple of years before they went to trial again. So they've been in prison for 35, not 30. It also simply is the first step in a long process, this recommendation. So although Thursday's announcement drew praise from the brothers' celebrity supporters and loved ones, the condemnation from critics. Why can't I? Words like slow me down sometimes, big words. I don't know why. It's like my brain forgets how to say them. Definitely, uh, autoimmune. See, I can't even think autoimmune disease related. I have brain fog all the time. All right, so although Thursday's announcement drew praise from the brothers' celebrity supporters and loved ones, a condemnation from critics who think Gascon is pulling an October surprise to boost his flagging election bid, the brothers' hopes of release still hinge on decisions from a series of arbiters: the LA County judge, the state parole board, Governor Gavin Newsom, and the potential inauguration of a new district attorney if Gascon does not get reelected. So the brothers were convicted in 1996. They were arrested in it was either 89 or 90. So yeah, they've been in prison for that long. So um the homicides took place in 89 and their first trial was in 93 with which ended in the mistrial. So then 96 was the conviction. So it was a conviction with special circumstances in the brutal homicides of their parents, Jose and Kitty Menendez, inside their Beverly Hills home. The only punishments for that crime under California law are the D penalty or life without parole, which is what they received. But on Thursday, Gascon said that he would seek to have them resentenced to a simple homicide charge, which would then make them eligible for parole because the homicides were committed when the brothers were less than 26 years old. Oh, geez, I didn't switch over to my other page. I'm sorry, guys. You're not even seeing what I'm reading. Oh, that's too big. That's good. Sorry. Okay, here we go. In a 57-page motion made public by late Thursday, Gascon's prosecutors argued that the brothers are no longer a threat to public safety and should be released given their exemplary behavior while in custody. Both brothers got married and obtained college degrees in prison, according to the motion, and started programs that benefit other inmates, including meditation groups and a green space project. Corrections staff rarely had to discipline them, with only one allegation of violence being made against either brother in their nearly 30 years, according to the motion. In recent months, much of the attention on the brothers' case has focused on a habeas motion seeking to overturn their convictions. Attorney Mark Garagos put forward new documentation to corroborate the brothers' claims that the homicides were motivated by years of SA at the hands of their father and mother. I want to reiterate this point because some people don't know this or fail to realize that Kitty also essayed Lyle. I don't know if she did with Erik, but she used to check his genitals when he was a teenager, like would yell at him to get undressed and she would check them. I don't know why. Um, and then, yeah, with Lyle when he was young, and through his like early teens, she was also essaying him. So, and telling him that she hated him and that he ruined her life and that she wished she never had him. So, there's that. So, if you ever wonder about Kitty, don't wonder anymore. But the prosecution claimed that they did this crime in order to gain access to the inheritance early, which is so stupid because they had access to money. They had more access to money with Jose alive because he got them everything that they wanted financially. He just didn't know how to be a loving, normal human being who loves their children. Anyways, but legal experts say the brothers might have a more direct path to freedom through resentencing, assuming that they've played by the rules and they've been in custody as long as they have, and they have only minor violations that would fit the profile of someone who qualifies for resentencing, said Lori Levinson, a professor at Loyola Law School in Los Angeles and a former federal prosecutor. Veteran Los Angeles County Superior Court Judge William Ryan will review the case later this year. He could immediately grant the petition, but it's more likely that he would hold a hearing where many of the family's loved ones could speak along with prosecutors opposed to Gascon's decision. There are a couple family members who are also opposed to the decision on Jose's side. I think Jose's brother and maybe a cousin or a nephew or something. Gascon acknowledged Thursday that there was not universal agreement on the case in his office, with some prosecutors opposed to the idea that the brothers could be resentenced. Another faction in the office had pushed Gascon to seek to resentence the brothers to manslaughter, which would have made them eligible for immediate release if Ryan granted the petition, according the judge, I believe, is Ryan, according to two sources with direct knowledge of Gascon's thinking. But he said in the press release he believed there was premeditation there, which I don't. I think they were protecting themselves and didn't realize they would have to use them that soon, the guns, when they bought them. So I don't know. Anyways, the sources requested anonymity in order to discuss the case candidly. Experts said that move might have been a bridge too far for Ryan and backfired. So if he had gone with the manslaughter, it might have backfired. Gascon's decision was probably the safest avenue he could pick, says Levinson. If Ryan grants the petition, the state parole board would then weigh in. Kathy Cady, a former prosecutor turned victims' rights attorney who represents Kitty Menendez's older brother, said the parole board tends to approve releases if an inmate's prison record is as nearly spotless as what's described in the motion. So apparently Kitty's brother? Yeah, Kitty's older brother is for this. And isn't that she was close with one of her brothers? That might be the brother that did that. Is for their what I was trying to say is that they are in support of the brothers being released. So as of October 23rd, the board granted parole in approximately 31% of the cases it heard this year, in which it rendered a decision according to California Department of Corrections and Rehabilitation's data. Even then, Newsom could reject the parole board's findings. Under California law, the governor can block the board's decision to grant parole if he finds evidence that the brothers' release posed an unreasonable risk to the public. So, we're not out of the woods yet, but potentially. Newsom has blocked the release of a number of high profile defendants in the California prison system, including Sirhan. I have no idea who that is. That's the assassin convicted of taking the life of Robert F. Kennedy in Los Angeles. Oh, okay. He also blocked the release of Charles Manson devotee Leslie Van Houten on 3 different occasions before stepping out of the way of an apology. Okay, but all of the Charles Manson devotees were still devotees. They never wavered in prison. So I think one maybe came forward after and was like, "Yeah, I feel sorry for what I did." But most of them were still truly obsessed with Charles Manson somehow. I think they fried their brains with chemical altering drugs. I don't know. All right, so a spokesperson for Newsom referred questions about the Menendez brothers to the Corrections Department. Attorney Nancy Terrault, who represented Van Houten, said she believes Newsom will block the brothers' release due to the intense media attention on the case. Doing so, she said, would trigger a lengthy court battle. When you have a high-profile client, you can expect to have several parole hearings because it is my experience that the governor will likely reverse the release, she said. When that happens, you have to go to the Court of Appeal and show why the governor is wrong. Gascon's decision could also be upended if he is no longer in office by the time the process plays out in court, although he said he doesn't think so. Some polls show Gascon's challenger in the November election, former federal prosecutor Nathan Hochman, leading by as much as 30 points among likely voters. Hochman has not taken a public position on the Menendez case, but has said he intends to review the decision if he displaces Gascon. In that particular case, I would analyze the thousands of pages of confidential prison records, the transcripts from both trials, and the voluminous exhibits, as well as speak to the prosecutors, law enforcement, defense attorneys, expert and victims' family members, he said in a statement. Only at that point would I be in the position to properly evaluate whether the resentencing request is correct. Levinson said it's unlikely Hochman could intercede. However, if Ryan grants the resentencing petition before Gascon leaves office, so she doesn't think if the judge grants it, then she doesn't think that Hochman may do anything. So there's still a road ahead that the boys have to follow, but there is some good evidence in this motion. So this is the people's motion requesting 1172.1 recall of sentence and resentencing hearing, memorandum of points and authorities thereof, proof of service. And I don't know what all of that means, but we're going to read through this. So, people of the state of California versus Erik and Lyle Menendez. To the Honorable Judge William Ryan of the Los Angeles County Superior Court, defendants Erik and Lyle Menendez, and all interested parties. Please take notice that as soon as can be heard, the people will move the court to recall the sentence of Erik Menendez and Joseph Lyle Menendez and resentence them in the interests of justice. This motion is made upon the grounds that the circumstances of the case warrant the court exercise its discretion and re examine the disposition in this case. The motion is based on the pleadings in this action, the attached memorandum of points and authorities, the attached exhibits, and on such oral and documentary evidence as may be presented at the hearing on the motion. And that's signed the deputy in charge and the assistant head deputy of the LA District Attorney's Office. Not Gascon, but they are they wrote this on his behalf, I'm assuming. All right, so the request for recall and resentencing, the people respectfully request this court recall defendant's sentence and resentence them pursuant to Penal Code Section 1172.1. Defendants have demonstrated exceptional post-conviction conduct, a critical factor in assessing their sustainability for release. Defendants have demonstrated they no longer present a public safety risk pursuant to Penal Code Section 667.5, such that their current sentence is no longer in furtherance of justice. Their current sentence is no longer in furtherance of justice, meaning that keeping them in prison doesn't serve justice anymore. The people therefore request the court vacate, recall, and resentence defendants. Procedural summary of the case. On March 12, 1990, a felony complaint was filed in the Beverly Hills Municipal Court charging Erik and Lyle Menendez, the defendants, with the August 20th, 1989 homicide of their parents, Jose and Mary Kitty Menendez. Her name was actually Mary Louise, which is funny, not funny, that the woman that Jose was having an affair with for like 8 years or something before Kitty finally like found out, stalked her, like flew to New York and stalked her and took pictures of her and all this. The woman's name was Louise, so that like got her more than anything was like this woman's name was her middle name, and well, she was never the same after that. But anyways, sorry, so Mary Kitty Menendez, she just went by Kitty. So it was also alleged that in the commission of the homicides, the defendants each personally used a firearm within the meaning of Penal Code Section 12022.5. Three special circumstances were also alleged against them: that the homicides were committed by the defendants for financial gain within the meaning of Penal Code Section 190.2A1, that the homicides were committed by the defendants while lying in wait within the meaning of another penal code, and that the defendants committed multiple homicides within the meaning of yet another penal code. The defendant's preliminary hearing was delayed due to litigation regarding the admissibility of tape recordings involving the defendants discussing the homicides of their parents with their psychotherapist. And I try to give emphasis to that psycho because I think their psychotherapist was pretty psycho himself. The district attorney's office then proceeded to the grand jury of Los Angeles County and sought indictments against the defendants for the homicides of their parents. On December 7th, 1992, the grand jury issued an indictment charging the defendants with the homicide of each of their parents and alleging the lying in wait and multiple homicide special circumstances. The defendants were also originally indicted for the conspiracy to take the lives of both Jose and Kitty Menendez in separate counts, but the government returned to the grand jury on April 14th, 1993 and sought an amended indictment wherein the defendants were charged in one count only with the conspiracy to homicide for both of their parents. On January 12th, 1993, the government announced they were seeking the D penalty against both defendants. So the first trial, it was potential that they would have been executed if they had been found guilty, but we know it was um, what am I trying to say? Uh, the jury decided on life in prison. All right, so the defendants were tried jointly commencing in June 1993 before separate juries. Neither jury was able to reach a verdict and declared a mistrial for both defendants. The defendants were retried starting in October of 95 before just a single jury this time, not two juries. And on March 20th, 1996, the jury found the defendants guilty as charged. The penalty phase resulted in verdicts of life without parole rather than death for the defendants in April 1996. On July 2nd, 1996, the trial court imposed consecutive terms of life without parole, life on the two homicide convictions, and stayed the conspiracy to homicide sentence pursuant to Penal Code 654. So, another thing I want to mention is that in the second trial, there was very limited information about the SA and the CAing that was going on in that house. So the jury didn't get the full picture of what life was like for those boys. So I think the sentence is unfair also. All right, so brief statements of facts. On August 20th, 1989, at approximately 10:30 p.m., defendants Erik and Lyle Menendez shot and took the lives of their parents, Kitty and Jose Menendez, as they sat on the family's couch watching television and eating. Actually, they were standing, but okay, let's get facts wrong. Both defendants repeatedly fired Mossberg shotguns at their parents, striking them multiple times with shotgun pellets all over their bodies. One of the Menendez neighbors heard a series of popping sounds at about 10:30 and then a period of silence and then another series of popping sounds. The neighbor's son was going to call 911 but was dissuaded from doing so by his father because he thought the popping sounds were simply firecrackers. When the boys told the law enforcement that they thought that uh, somebody, a neighbor, would have called right away. So they sat around for a few minutes and they're like, wait a minute, no one's showing up. Like, no cops are here. No one's coming here to arrest us. So they didn't really know what to do at that point. Then they went and they cleaned up the shells, and then they went and drove around and got rid of the guns, and they went to go get the movie tickets, which ended up not even working for an alibi for them. At the times of the homicides, Lyle Menendez was 21 years old and a student at Princeton University, while Erik Menendez was 18 years old and preparing to attend UCLA in the fall. On the afternoon of August 20th, Lyle Menendez had called a friend and discussed getting together that evening at a food festival in Santa Monica. Lyle Menendez told the friend that he and Erik Menendez were going to see a movie in Century City, but after the movie finished around 9:30 p.m., they would go meet up with a friend in Santa Monica. When the defendants did not show up in Santa Monica, the friend left. Lyle Menendez called the friend twice at approximately 11 p.m. In the first call, Lyle Menendez said that he got lost on the way to Santa Monica and that by the time that he finally found the location, the food festival was closed. Lyle Menendez suggested the friend meet him and Erik Menendez at a restaurant in Beverly Hills. The friend was reluctant, but because Erik Menendez was very inconsistent and sounded anxious and excited, the friend ultimately agreed. Lyle Menendez called the friend again just a few minutes later and asked him to meet the defendants at the Menendez home instead of the restaurant. The friend told Lyle Menendez he would wait at the restaurant for the defendants instead, but the defendants never appeared. The friend was angered by this behavior and went to the Menendez home to yell at the defendants, but then saw a large number of police outside and was told by the police there was some trouble, so the friend went home. At 11:47 p.m. on the night of the homicides, Lyle Menendez called 911 and said someone KILL'd my parents. Lyle Menendez said that he had not heard anything unusual. He had just come home and discovered that his parents had been shot. police officers responded to Lyle Menendez's 911 call. When they reached the front of the Menendez residence, Erik and Lyle Menendez ran out of the front door of the house. The young men were screaming. The investigating detective did not recover any ammunition inside of the residence, nor were any shotguns located. And they threw them down the hill when they were driving. All right, so the defendant spoke to the police the night of the homicides as well as again in September of '89, so the next month. In both interviews, the defendants said that they were elsewhere at the time of the homicides. At the time of the first interview, Lyle Menendez indicated the possibility that the homicides were business related. Within a few days of the homicides, Lyle Menendez hired a security services company to provide constant protection for him while he was on the East Coast. Lyle Menendez took the security company that his parents Lyle Menendez told the security company that his parents' homicides were committed by an organized crime group, a story he repeated to other people over the next few months. Erik Menendez testified at trial that he had been physically and intimately aided by his father, Jose Menendez, between the ages of 6 and 18. Erik Menendez testified that he loved his parents, but he took their lives because they were going to take his first after he had disclosed to his brother Lyle that his father had been SAing him this whole time. Lyle actually knew about it before because Erik told them when they were much younger, and Lyle told his dad to stop. His dad said he would. Years later now, they're adults, and it's still happening. Erik Menendez told Lyle about the molestation 5 days before the homicides and told him it had been ongoing for the past 12 years. On August 17th, Lyle Menendez confronted Jose Menendez about the molestation of Erik Menendez and threatened to tell the police or relatives if Jose did not stop. Erik testified that he believed both he and Lyle would die as a result of Lyle's threat to expose Jose to the world. The next day, Erik and Lyle purchased the Mossberg shotguns that they used in the murders with cash at a sporting goods store in San Diego. At the time of the purchase, Erik presented a California driver's license in someone else's name, that was their friend, someone else's name, and gave a non existent home address in San Diego. Erik Menendez later testified at trial that he and Lyle Menendez picked up the ejected shotgun shells at the homicide scene because they believed their fingerprints might be on them. The defendants left the house and stopped at a car wash where they dumped the shotgun shells and the bloody clothes in the trash. Erik Menendez testified he also feared his mother, Kitty Menendez, because she participated in her husband's behaviors, and not only did she condone it, she contributed to the A in the house, definitely. In his testimony, Erik Menendez made clear that in the days preceding the homicides, he thought his parents were going to take his life. There was a planned fishing trip on August 19th that the defendants tried to avoid because Erik Menendez was afraid the fishing trip was a ploy to take the defendants out at sea. They thought that was going to happen then at this fishing trip. Ultimately, the defendants returned home, and then their parents took them to a fishing trip. During the entire time, an independent witness corroborated that the defendants stayed at the front of the 31-foot boat. Erik Menendez testified this was because they were afraid of their parents. They both testified to that. Evidence was, I thought Lyle said the same. Evidence was presented at trial of the defendants' efforts to convince two of their friends to testify falsely. One friend was asked by Lyle Menendez to testify that the day before the homicides, the defendants came to him and said they needed a handgun for protection from their parents. The other friend was asked by Lyle Menendez to testify that Jose Menendez had done to her what had been done to a character in a movie the friend had seen with Lyle Menendez. Lyle Menendez told the friend she would receive a large sum of money if she testified accordingly. Both friends refused. At trial, the people also introduced 9 pages seized from Lyle Menendez's jail cell before the first trial. The 9 pages contained references to safe houses in foreign cities, as well as international travel and visas for different countries. So apparently, they had plans to flee, potentially. All right, so I'm not going to read through all of this. Some of this is like boring law stuff, but I'm going to just go through some of the points. So, this is the memorandum of points and authorities. So, these are the reasons why, or at least the law giving the DA the jurisdiction and the authority to be able to resentence. So, I'm not going to read through all of these. Basically, that's what it says. So, legislative history, district attorney's authority to recommend recall and judicial discretion granted under this particular penalty, or I'm sorry, penal code, not penalty. Here, purpose and legislative history they give you. We don't need to read all of that. It's kind of, yeah, I'm going to skip through all of this. District Attorney's authority to recommend recall and resentencing through another bill. So he's just citing all the ways in which they can do this. The court's discretion and judicial discretion to recall sentence and re-sentence a defendant. I want to get to this stuff about Erik. All right, so the defendant's post-conviction factors show that their sentences of life without parole are no longer in the interest of justice. The court should resentence Erik and Lyle Menendez to 50 years to life under Penal Code Section 1172.1. So this section lays out factors that this court must consider in recall and resentencing procedures. Subsection B2 sets forth a presumption favoring recall and resentencing, which may only be overcome if a court finds the defendant is an unreasonable risk to the danger of the public. So you would have to absolutely find them an unreasonable risk. Here the factors: Menendez's current age, 54 and 56, their age at the time of the offense, and their rehabilitative efforts in prison all favor resentencing. The presumption, moreover, stands because Erik and Lyle Menendez pose no risk of danger to the public. Therefore, the people recommend this court resentence a sentence of 50 years to life. The statutory factors support resentencing. Now 54 and 56 years old, the Menendezes pose a low risk of committing a new violent felony while serving a 50 years to life sentence. Erik and Lyle's current age supports resentencing because it has reduced his or their risk for future violence. Erik Menendez is 54 years old. Lyle is currently 56. Studies show that criminality declines drastically after the age of 40 and even more so after the age of 50. I did not know that. That's interesting. Indeed, the California Court of Appeal has highlighted the dramatic decrease in recidivism of people serving life sentences due to their age. Similar studies reflect the correlation between age and reoffending for individuals in felony custody. Commission the effects of aging on recidivism among federal offenders at page 3. Okay. Given their age, their risk of committing a new violent felony while serving a sentence of 50 to life is extremely low. Their respective ages, therefore, weighs in favor of resentencing here. The age at the time of the offense, the court is required to take into account the age at the time of offense. Both Erik and Lyle Menendez were youth under 26 years old at the time of the charged offense. Indeed, Lyle Menendez was 21 years old. Erik was 18 at the time of the crimes charged. As a result of recent scientific developments and changes in the law since the time of the sentence, the mitigating force of youth as a sentencing factor is now well and clearly established. The court, the High Court, recognizes that youth is more than chronological fact. It is a time of immaturity, irresponsibility, and recklessness. It is a moment and condition of life when a person may be most susceptible to influence and to psychological damage. And its signature qualities are all transient. So, there you have it. All right, moving on. The widespread recognition of youth as significantly mitigating contrasts with the perception at the time of the homicide trial. So, at that time, we didn't have this idea that our brains aren't fully developed. We know better now, and we should do better now. And even if that means going back and fixing the wrongs of the past, we should do that too, because why shouldn't we? If we know better, do better. So at that time, courts took the outdated view that a defendant's youth was a metonymic. Let's look that up. I don't know that word, and I would like to. So, Etoy. Oh no, an O Y. Why I can't hear it. It's not playing. A metonym is a general name that is rejected because it is based on a type of species that it. No, I don't think this is the right word. Hold on, let me find it. All right, I found it, I think. Metonymy is the word. It's a figure of speech that uses the name of one thing to refer to something else, something related to it. So it's the legal context. An example of metonymy is using the term the state to refer to the legal organization of a country or an area. So, like we refer to the people is metonymy, a metonymic word. So I guess that's what that means. I don't know. So, all right. So at that time, courts took the outdated view that the defendant's youth was a metonymic factor. Sorry, my hair is like staticky sticking to my head. Want it off of my face. A metonymic factor capable of being either mitigating or aggravating. As a result of a growing scientific understanding in the decades since this sentence was imposed, courts now recognize that incomplete brain development renders youth less capable of confronting conduct to that required by law, and that key features of the brain continue to undergo significant changes throughout a person's 20s. That is huge that we know this now. We didn't know this in the 90s when we locked them up and threw away the key. So we need to go back and fix it. In other words, there is certainly no indication that young offenders' capacity for growth and rehabilitation disappears simply because a young adult has passed the age of 18. Instead, the frailties of youth that lessen culpability continue until at least the mid 20s. Like the courts, the California legislature has similarly recognized scientific developments from recent decades which show the significantly mitigating role of youth and accompanying maturity to culpability. The legislature has incorporated these principles through various penal code reforms, including Section 1016.7, Subdivision B, which is incorporated to another section. Factors that weight in favor of resentencing, providing youth offender parole hearings for any qualified incarcerated person convicted of controlling offense committed prior to the age of 26. So the youth's transience, in combination with what is now known about adult and young adult brain development, renders it undeniably mitigating. As individuals mature, the impetuousness and recklessness that may dominate in younger years can subside. So you become less reckless and yeah, you're not in your younger years, you might be more susceptible to outside influences and things of that nature. Eric and Lyle Menendez's youth at the time of the crime is a highly mitigating factor, the importance or the import of which was not fully understood or recognized at the time of his initial charging and sentencing, and it weighs in favor of resentencing them to 50 years to life. Evidence of the essay, physical, violent tendencies, there was this case more than most cases had more evidence than most cases usually do. So for people to still to this day say that they don't believe or that they made it up, that's the prosecution told you that, the news told you that, and you've been brainwashed because it 100% is real. The DA validated it right here. So, if taken as true, both the testimony of Erik and Lyle Menendez and the probation reports prepared on July 2nd, 1996 documents several allegations of physical and SA by the family members, both Kitty and Jose. Specifically, Lyle Menendez reported that and testified that his father, Jose Menendez, molested him until he reached the age of 8 years old. Started at 6, and then he preyed on Erik and stopped with Lyle. The essay stopped, but Lyle reports that he continued to see violence until about 11 or 12. I would say he probably just got totally used to it and didn't notice it anymore. Erik Menendez reported that when he was 6 years old, his father, the victim in this case, began to molest him, making Erik Menendez massage and orally copulate him. When Erik Menendez was 12 years old, Jose Menendez began sodomizing him. At some point, Erik Menendez disclosed to his older brother, then 13 years old, Lyle, that Jose was R-ing Erik. Lyle Menendez, in a separate probation interview, reported that at the age of 13, he confronted his father about the CA of co-defendant Erik Menendez. He felt good about the confrontation and thought that the actions had stopped. Marta Menendez Cano, the defendant's paternal aunt in North Palm Beach, Florida, reported to the Los Angeles Probation Department when they interviewed her for Lyle Menendez's sentencing report that the defendants feared their father. When Erik was 12, he was beaten by his father for suspicion of telling Lyle about the SA that was going on between him and his father. The secrecy that is typical in SA cases was evident by the anger Jose would show if anyone came to their home unexpectedly. Erik was not allowed to call or receive calls from his cousin Andy. Marta Menendez Cano also reported to the Los Angeles Probation Department that one time Jose sat Erik and Andy down in the den to show them an educational video. The video turned out to be hardcore, rhymes with corn. As related to the defendant's mother, Kitty Menendez, Ms. Menendez Cano reported, so this is the sister of Kitty, reported if Erik got sick at school, he would beg his teachers not to call his parents. If he stayed home sick, his mother would put him in the closet and make him stay there from 8 a.m. to 3 p.m. He would be punished greater if he came out of the closet without permission. Andy was the only person who knew what was happening to Erik. Diane Vandermolen, they spelled that wrong, The defendant's cousin stated to probation at the time of the sentencing report that her Aunt Kitty was her mentor in life. I adored her. However, Diane noticed a huge change in Kitty's behavior. When Erik was around 11 years old, Diane saw him sobbing about something. When she went to confront him, Kitty physically stopped her and said, "We don't hug Erik anymore." What? You don't hug your kid? "We don't hug Erik anymore," she said. Wow. Okay. As the kid sits there crying, 11 years old. Erik Menendez went on to state that after they moved to California in 1986, the CA stopped for a while. However, a week before he turned 16 in November of 86, his father entered his room, ordered the defendant to get on his knees and orally copulate him. This continued to occur every 1 to 3 months until August 10th, 1989, 10 days before the present offense. Defendant was to start at UCLA in the fall semester and was going to be living in a campus dorm. However, a week before the present offense, father told defendant that he would be coming home several nights a week, which would be a nightmare to anyone who is experiencing SA from their father at home, having to come home and stay there several nights a week so that father could do his homework. So that's the reason. Sure. But the dad did do a lot of their homework. The probation department sentencing report for Erik Menendez also noted that Erik Menendez reported that his mother said she knew what was happening between defendant and father. The CA and trauma incurred by both defendants in this case is sufficient to invoke court consideration under a bunch of codes. Erik Menendez's path towards rehabilitation supports the imposition of a new sentence. Erik Menendez's discipline record, I'm not going to go through it all, but yeah, maybe we will. Okay. The court may consider a defendant's prison disciplinary record as one factor among others in evaluating whether he should be resentenced. Here, Erik Menendez's overall disciplinary record while incarcerated isn't reflective of his positive trajectory throughout his period of incarceration. Erik Menendez has received 8 violations in over 30 years. That's really not too bad. In 2021, there was possession of a phone found in his pillowcase in a cell Erik shared with 5 other men in the prison. In 2018, Erik Menendez was laying on inmate Segura's bed in inmate Segura's cell, a cell that he does not share with Menendez. While talking with a few other inmates, there was a cell search while the men were in the cell, whereupon a cell phone was found. So it's not even his. Why is he getting written up for it? That makes no sense. In 2011, he got in trouble for fighting mutual combat, hands and fists. Erik Menendez reported that the other inmate came over and assaulted him. In 2006, excessive physical contact with a female visitor. Uh-oh, he got a little handsy with his wife or girlfriend or somebody that came to visit. 2005, unauthorized possession of uncontrolled medication. Erik Menendez pretended to take his Wellbutrin. The guard asked to see the cup Erik Menendez put to his mouth. The pill was still in the cup. And you get written up for that? Okay. In 2003, possession of tobacco, refusal to provide urine sample. In 97, battery requiring the use of force. Erik Menendez assaulted another inmate. The men did not stop fighting when ordered to. The guards had to use force, sure, to stop fighting. It just says to use force. So, there. All right, so in 97, disobeying an order, Erik Menendez refused to leave the chapel after the yard had been recalled. So he didn't want to leave the chapel. Seriously, there's really not too many. He doesn't seem like a violent offender. I mean, is there some fighting involved? Perhaps. I imagine that these boys are probably, some people, they've been starting these programs and helping others rehabilitate, but I'm sure there's the faction of prisoners, inmates in there that still think that they did it and are going to cause problems and get in their face about it and be like, whatever. There's still probably that faction of people that are going to take the state side, and even though they're prisoners too, but they're going to think that the boys are guilty and maybe that causes them some problems. I'm not really sure. They have some predictive scores, not really sure how this works. They're saying he's readjusted to a 19 or something like that. I'm not going to read through all of this. He's educated. He's highly productive in the learning environment. He went and he got his Associates of Arts degree in sociology with honors. He was accepted into Phi Theta Kappa Honor Society. Menendez earned his certificate in proficiency in American Sign Language. Like they have not been sitting still in prison. They've been doing a lot. I'm not going to read through all of it, but as you can see, this next portion is self-help. It's going to get loud. Hold on. All right, this next part I just want to skip through really quick. So, self-help and recovery programming. Eric Menendez has proven himself to be an incredible asset to the prison community. He has created 4 new programs within the R.J. Donovan Prison to assist and better his fellow inmates' quality of life. Specific programs that Eric Menendez created include Life Care and Hospice Connections. Eric, along with a fellow inmate, co founded and facilitated the Life Care and Hospice Connection program. Life Care and Hospice is an American with Disabilities Act awareness and support group that provides support for the disabled and elderly inmates. It also serves to educate non ADA inmates on the physical and emotional struggles of the less abled peers. And then there's a bunch of um, I'm assuming documents, exhibits, things that these boys have done. I'm not going to read through it all, but it is a long list of things that they have accomplished in prison. So I'm just going to scroll through it while I'm talking because, as you can see, it's pretty long. So, like here, he was acknowledged as a facilitator of the ADA Awareness Support Group. So all these different bullet points are ways in which they helped or contributed to some kind of program or something. So that was just Eric. He also did this Vive. Eric Menendez created the Victim Impact and Victim Empathy for Vulnerable Populations in 2022. In explaining the program, Eric Menendez wrote, in order to accommodate more students for life care and hospice, post-COVID, the class was restricted from 50 students permitted to 25 students in one space. I was granted special permission by the RJD, Prison's Mental Health Department, to hold 8-week victim impact and victim empathy workshops. Vive is the victim impact part of the life care and hospice curriculum. So he's inventing workshops and all sorts of things here to help different inmates of different types. He's been big in helping victims of SA and CA, 12-step and meditation class. He co-founded the 12-step recovery meditation class. He facilitated 8 sessions here, facilitated a 9-hour workshop. He's doing all of this in prison. He's teaching classes in prison about all of this after he taught himself how to do it. Like, that's pretty amazing. All right. In 2018, Eric Menendez created a meditation program for the inmates at R.J. Donovan Prison. Eric Menendez explains his reasoning for creating the program. In my central file, I have numerous documentation of my work in and participation in meditation as it connects to mindfulness and cognitive behavioral therapy. I have practiced meditation for 25 years. Meditation has changed my life. In 2018, I created Insight Meditation to help teach inmates about physical, emotional, and spiritual benefits of mindfulness meditation. Some more examples of Eric's leadership in the programs documented below, more facilitating of groups and things. Not going to read it all. There's so many. Starlight Peace Program in October of 2018, Erik Menendez co-founded the Starlight Peace Project. The stated mission of the Starlight Peace Project is to create or capture images of peace in places associated with violence and human struggle. In August, Erik is very artistic. He has started art programs. Um, he's really into art and seeing the beauty of things. So, on August 28th, 2018, Chrono from E. Garza documented that Erik Menendez and his Starlight co-founder served as co-directors for the Nonviolence Challenge. They were responsible for supervising 30 event coordinators and over 150 event participants, including organizing the event, working with administrative staff to gain necessary permissions to hold the event, and coordinating with San Diego State University staff to complete the No Violence Challenge. It is important to note that at one point, with all the programs and classes Erik Menendez founded, Erik was and may still be teaching 5 different classes in the course of a week. He's busy. Their dad taught them to be successful, so they're going to be successful no matter where their situation is, and their situation just happens to limit them to being in prison. But they're making the most of it. They're making the most of their lives in prison by doing all the things that they're doing. Alternatives to violence training. Erik has completed the alternative to violence training courses. He has successfully trained to be a facilitator in that program as well. He's facilitated it multiple times. Erik's record of participation in his community. He's very active in the prison. As you can see, I am scrolling, fingers hurting. This is a lot of things that he's contributed to. Sobriety maintenance. Despite not having a documented history of alcohol or substance abuse, Erik Menendez has aggressively engaged in sobriety maintenance programming. In addition, his founding of the 12-step meditation program, Erik Menendez actively participated in AA and NA programming. Examples of this include all of these other examples. So many, many things. He's got a work history. I'm going to go over that. Up next, Lyle. So Lyle's post-conviction factors show his current sentence of life without parole is no longer in the interest of justice. Lyle has established an overwhelming record of rehabilitation in satisfaction of the considerations for recall and resentencing contemplated under Penal Code Section 1172.1. His in-prison record demonstrates sustained compliance with departmental regulations, rules, and requirements, as well as prolonged participation in rehabilitative programming. Lyle's disciplinary record. As stated above, the court may consider a defendant's prison disciplinary record as one factor among others in evaluating whether he should be resentenced. Here, Lyle Menendez's overall disciplinary record while incarcerated is reflective of his positive trajectory throughout his period of incarceration. Lyle Menendez has had 5 rule violation reports in over 30 years of incarceration. Only 5. Erik had more than 5. So Lyle's been on better behavior than Erik has. He had a cell phone possession of this year. He had a phone in his possession that he shared with multiple people. It was the first occurrence. No STG nexus. I don't know what that means. Misuse of state phones. That was in 2000. Lyle was using the phone when he shouldn't have been. 2013, possession of contraband. He had a lighter. Oh boy, what a violent offender. 1988. Does he mean 89 or 98 maybe? Receiving because he wasn't in prison in 88. Receiving contraband, a female visitor brought him new Adidas shoes in the visiting room. How awful of him to have new shoes. I don't think he was supposed to have them. All right, so 96, refusing an order. Lyle Menendez refused to leave administrative segregation when ordered to join the orientation dorm. All right, so really, they don't have a whole lot on their records as of offenses. It is important to note that Lyle has not been in a single fight in the 30 years that he has been incarcerated. In 97, he had to move from general population to the special needs yard because he wouldn't fight back when attacked. All right then. So he's become a total pacifist, which is not what I was expecting, but that's cool. All right. So Lyle Menendez, current California static risk assessment. Oh, he's what also readjusted to a 19, whatever that is. I don't know. There's some number that they give them. So they're considered both low risk reoffenders. Lyle's post-conviction factors and inmate sustainability for release may be premised upon the showing of overwhelming evidence of rehabilitation. Here, Lyle Menendez has programmed extensively during his more than 30 years of incarceration. Education, he got a bachelor's degree, reported that he was on the dean's list every semester and was nominated for the National Merit Society in 2023. Lyle received a U.S. Senate Certificate of Commendation from Senator LaFonza Butler to congratulate Lyle's graduation from UC Irvine through the Lifted program. Prior to attending UC Irvine, Lyle earned his associates in sociology. What else? All right, so self-help and recovery programming. Lyle Menendez has proven himself to be an incredible asset to his prison community. He has held significant leadership roles for more than a decade, as documented in a March 16, 2017 laudatory chrono from Associate Warden of Program and Housing. In the March 16 chrono, Associate Warden Holmes noted that Lyle Menendez was elected representative for prisoners in Northern California prisons back in 2003. For over 10 years, serving in that capacity, he has worked productively with the administration to foster a positive programming culture at MCSP. Associate Warden noted that in 2003, Lyle Menendez was able to convince prison population on max security yard to live alongside the mental health program prisoners, resulting in the CDCR not needing to build a separate yard. In 2007, Lyle Menendez worked with inmate population to build consensus to allow integrated housing to be implemented by CDCR without inmate pushback. Lyle went cell to cell, speaking to inmates individually to garner cooperation. Because of his ability to garner inmate buy-in to integrated housing, the CDCR was able to close a disciplined dorm. Furthermore, Lyle Menendez drafted the bed move section. All right, all the dogs have to get up and make a bunch of noise at the same time. Sorry. All right, so because of Lyle's ability to garner inmate buy-in to integrated housing, the CDCR was able to close the discipline form. Furthermore, Lyle drafted the bed move section in Title 15 Regulations Code, which is still in effect today. program development. In addition to being a leader amongst his peers, Lyle has created 4 new programs within the prison system to assist and better his fellow inmates' quality of life. Specific programs that Lyle has created: a green space project that was developed in 2018. It was a 2-phase project to beautify the prison. The project will paint enormous landscape murals along the entire interior of the facility exercise yard wall and redesign the prison landscape. To undertake this project, Lyle founded the Rehabilitation Through Beautification group. Project began 5 years ago. Lyle Menendez has partnered with various local businesses, landscape developers, all levels of prison administration. He has raised over $250,000. In addition, Lyle has garnered with Guide Dogs of America to raise $100,000 for artificial grass materials. Lyle has been entrusted by the CDCR administration to be in charge of inventory control for the project. I mean, my God, did these guys work for the prison or are they inmates? Seriously. Rehabilitation through beautification. Lyle Menendez, in further of the Green Space Initiative, founded the Rehabilitation Through Beautification volunteer work group for inmates to participate in the green space mural painting and landscaping improvements. Adverse Childhood Experience in Rehabilitation, or ACER. Lyle founded the ACER program in 2016, and it seeks to provide non-clinical framework for offenders to explore their own childhood history and its causal relationships to personality traits that can lead to criminality. That is a great program. Understanding is key. That's a great program that he put on there. All right, Youth LWOP Ally. Lyle Menendez founded a group made of exclusively of youth offenders from LWOP sentences for the purposes of mentoring non-LWOP prisoners who were working on their rehabilitation goals. I'm assuming that is like a type of prisoner or where a prisoner is located in the LWOP. No, life without parole. That's what it means, life without parole. So he is he founded a group of exclusively youth offenders with life without parole sentences for the purposes of mentoring the non life without parole prisoners who are working on their rehabilitation goals. So giving the life without parole inmates a purpose by helping the non life without parole inmates to better themselves. That's an interesting take. I like that. Wire Bulletin. Lyle Menendez created and wrote the Wire Bulletin, an inmate advisory bulletin for the purposes of communicating inmate advisory council matters to the population. The Wire Bulletin was reported by RJD Mental Health to help keep low functioning prisoners in the mental health program better informed. It was noted that using a bulletin method is important when a facility has an what is EOP again? EOP unit. I don't know. As those inmates often will not or cannot digest full page memorandums, minutes on a wall, but will read a bulletin with brief updates. So bulletins are key. They have created this bulletin program. Often one roommate will read the bulletin out loud to their lower functioning roommates. For this reason, the Wire Bulletin is supported by mental health. Additional programming, I'm not going to go through it all, but he's done a lot as well. Circumstances have changed since the original sentences were imposed. A sentence of life without parole is no longer in the interest of justice. Presently, there is no statutory definition of what qualifies as being in furtherance of justice. However, when dismissing criminal charges prior to conviction, it is established that such considerations require weighing and balancing of an individual's constitutional rights against the general interests of society. When determining whether the appropriate circumstances exist to justify sentencing at minimum, there must be an identifiable reason for doing so that is sufficient to motivate a reasonable judge. Erik and Lyle's positive transformation, as well as their ability to find meaning and purpose from their current confinement, illustrate just how much circumstances have changed since the time they were sentenced to life without parole. My journey of healing, making amends, and understanding my life crime, along with the process of rebuilding my life, has been long and challenging. I had to let go of the only value system I have ever had, beliefs and principles instilled in me by my parents from infancy, and explore anew the meaning of values, love, and compassion within a community. I had to reshape my understanding of success and reevaluate what it means to live a life of true purpose. Today, I find my value in the exchanges of kindness I have with others, in living as a caring and loving husband and father, and in trying to be a compassionate friend and a helpful contributing member of my community. To this end, the principles of my life have become rooted in empathy and, where possible, in service. And that is from Erik Menendez. The unprecedented publicity surrounding the case and my own admissions as a survivor of SA brought an outpouring of communication with other victims of R and incest across the country and the world. I decided early on in my incarceration to connect with survivors. My own life will never be free of suffering, but I found a way to use shared experiences to help others and myself heal and understand this complex trauma. I asked my family to create a public figure Facebook page in my name as a safe space for survivors of SA. I have spent countless hours with my family helping contribute to its contents through the mail and over the phone by audiogram. The site is visited by tens of thousands of SA survivors each week. In addition, I have personally written thousands of letters to victims in response to their letters to me. The sharing has been a profound experience and helped my own healing process. Another surprising result of being so public about my own SA is the enormous number of prisoners who have confided their own shameful experiences with this trauma. They found in me a safe place to share. As a result, I have spent 2 decades facilitating groups informally and formally for prisoners who experienced SA as children. I founded a group called ACER, see the ACER memorandum, that allows groups of prisoners to understand their past childhood trauma. Networking with mental health experts outside the prison, we were able to allow professional feedback and provide guidance. That was from Lyle. Erik and Lyle have committed their crimes when they were 18 and 21. They were admitted to CDCR at ages 25 and 28 years old, respectively. Having experienced a significant amount of trauma and abuse as children, today they are 54 and 56-year-old men who have both demonstrated a deep sense of self awareness and connectedness to a positive, pro social community, both inside prison and outside in the community they intend to return to. Erik and Lyle Menendez have done a tremendous amount of self work while in custody and are now able to use their life experience or their lived experience to support and help their communities. With respect to Erik, Correctional Officer V. Freeman, Inmate Assistant Program Supervisor, Richard J. Donovan Correctional Facility wrote, when asked about his commitment and commendable work ethic as a caregiver for the elderly and ADA inmates, Menendez stated, my maturity has taken time through a lot of failures and insight. I have a great deal to make up for. The truth is, in assisting and serving the handicapped, they have healed me more than anything I could do for them. Menendez's efforts and passion as a caregiver has had a contagious and positive effect on the quality of care given by numerous members of his crew. He has helped change the face of caregiving for the elderly and handicapped on his own watch. As such, his conduct should be commended and documented for future supervisors. CDCR staff, program leaders, and employers have recognized Erik and Lyle's transformations in a letter of support for consideration of resentencing Joseph Lyle Menendez from April 23rd. Hold on. Sorry, we've got house improvements that we're working on. So, my boyfriend's probably gonna be making noise, but we're almost done here soon. And sorry for the distraction. It's hard to record when we have lots going on here. All right, so the CDCR staff, program leaders, and employers have recognized Erik and Lyle's transformations in a letter of support for consideration for resentencing. Here it goes. I did not know Lyle Menendez prior to his arrival at RJDCF. Therefore, I can only provide my evaluation of him while he was assigned to Facility E. However, I believe the time I have supervised him gives me a very reliable assessment. Furthermore, a review of a central file memorandum written by the Mule Creek State Prison Associate Warden of Program and Housing, Brian Holmes, which describes the conduct of Mr. Menendez over the 10 years prior to his arrival at the current facility he's at, the RJ, I'm just going to say RJDF. Oh boy, what did I do? That indicates a similar assessment of his exhibiting exceptional conduct, a high degree of character and trustworthiness, detailing the numerous ways he contributed to the safety and stability of the prison for inmates and staff alike. These two assessments show consistency of character and exceptional conduct spanning the last 15 years. I, along with many of my colleagues, whom I know share these sentiments, strongly urge the court, the district attorney, the governor of California, and any other relevant government bodies to reconsider the resentencing of Lyle Menendez. I believe that providing him with a second chance at freedom is consistent with our belief in the legal system to provide when an individual has truly changed their life for the better of their families, communities, and himself. Should there be any need for further discussion or information regarding this matter, please know that I am fully prepared and willing to assist in any way possible. If helpful, I can also be available to appear in person at any relevant proceedings. That's pretty big when they're willing to go above and beyond to vouch for someone in prison. Both Erik and Lyle have been recognized for their work ethic, professionalism, and being significant contributors to the betterment of the community that they live in. So, what makes us think that they wouldn't come out into society and also be significant contributors in the free world and not behind prison doors, prison walls? I think they should have the opportunity to be free and do good things for victims, survivors of SA and CA and any kind of A. They are, they could probably make a huge living doing, just motivational speaking. And that alone would be like so helpful to so many people. Anyways, so they have created, over the 30 years, Erik and Lyle have participated in victim impact programs, workshops, and events. They have created multiple programs in service to those in need around them. Both the prison environment and the prison administration of the facilities they have resided at have greatly benefited from their contributions. The CDCR was actually able to close an entire discipline dorm based on Lyle Menendez's ability to build consensus among inmates and the administration, which is just like amazing. He's a good negotiator. Erik and Lyle Menendez understand the harm that they caused extended far beyond the direct victims of the offense. Their crimes have impacted their families, friends, and community more broadly. It is important to note that other than the two fist fights that Erik was in 97 and 2011, Neither Erik nor Lyle have engaged in a single act of violence before the crimes in this case, nor have they engaged in any form of aggression after the crimes were committed during the entire 30-year period of incarceration. I want to say your chances of being in a fight if you're in prison probably increase tremendously if you are a prisoner or an inmate because it's dangerous in there. So if you're protecting yourself, yeah, you could easily get some kind of offense for being in a fight when really the other person might have attacked you and you were just defending yourself. But we don't know the situation. He might have attacked. Who knows? We don't know that first situation or the second situation. So, well, the second situation said he was being attacked, but I don't know what the first one was. Anyways, all right. So they have never been found in possession of a weapon and have never affiliated with any of the prison gangs. The homicides of Jose and Kitty in August of 1989, although clearly planned, came upon, I don't think that it was clearly planned, came upon the heels of years of alleged SA and emotional A, removed from the horror of what was described to have occurred in the family. Both Erik and Lyle have shown themselves to be empathetic individuals who care for and participate in the community for the betterment of the collective. And that's the key, really. I mean, if they are going, can't I highlight it? Okay, it's not letting me highlight where I want to highlight. Trying to say for the betterment of the, okay, forget it. I'm just trying to highlight the community. They're empathetic individuals who care for and participate in the community for the betterment of the collective. That's an important factor that could help them get out. A review of each defendant's prison file shows that there is no evidence that either Lyle or Erik would be likely to commit a super strike upon release. I'm not going to read this Mary's Law. What is Mary's Law? Marcy's Law. As relevant here, pursuant to Marcy's Law, victims of crime have a right to reasonable notice of all public proceedings, including delinquency proceedings upon request, at which the defendant and the prosecutor are entitled to be present of all parole and other post-conviction release proceedings to be present at all proceedings. It is widely known that the members of the Menendez family are in full support of the resentencing of Erik and Lyle. Members who have voiced their support include Kitty Menendez's sister Joan Anderson Vandermolen, who at the age of 93 flew into the state of California to participate in a press conference called by the family to voice their desire to have Erik and Lyle resentenced. She also attended a meeting with the Los Angeles District Attorney in compliance with Marcy's Law, accompanied by almost 30 other extended family members, wherein they all expressed their support of Erik and Lyle Menendez being resentenced. Family members in support of the resentencing of both Erik and Lyle Menendez collectively confirmed that the men were SA'd by Jose when they were children, so they all agree that it actually did happen up until Erik was 18. There is a single family member, Milton Anderson, who is opposed to a resentencing of any kind. He declined to meet with the deputy district attorneys assigned to assess this case to discuss the Marcy Law's rights or give direct input. So he's objecting to it, he's opposed to it, but he's not going to try to fight for it. So he must not object that much. Mr. Milton, however, has made his opposition clear through his attorney's public appearances and statements issued to the press, expressing his total opposition to resentencing, disbelieving that any abuse had occurred in the Menendez family home prior to the homicides. It is expected that Mr. Milton Anderson will make a personal statement when the motion is litigated. Interesting. I'd like to know what his reasons are. The court should use its broad discretion under Penal Code Sections 1172.1 to resentence the defendants. To date, Erik and Lyle have each served 30 years of their current sentence, with Erik and Lyle Menendez when they were sentenced to life without parole in 96, their sentences were aligned with what was considered the best public safety practices. What is considered best practices for public safety, however, has evolved. Oh my God, I'm trying to highlight the exact opposite of what's highlighted, and it's just doing, yeah, okay. So what is considered to be best safety practices has evolved, so should our laws. So we now understand that public safety is not best achieved through overly harsh punishments that ignore rehabilitation. Instead, public safety is best achieved through a combination of punishment, rehabilitation, restorative justice, and proportionality and meaningful community engagement, including re-entry support and services to the victims of the crime. While incarcerated, Erik and Lyle have transformed and taken advantage of meaningful opportunities to mature, move beyond criminal thinking, repent, and become a productive community member. Both members have been incredible contributions have made, sorry, both men have made incredible contributions to the prison system as a whole and to their fellow inmates on a very personal level. Erik and Lyle have done and continue to do good works and contributions done without any expectation or hope of ever being released. While incarcerated, Erik and Lyle have shown themselves to be contributing and functioning individuals. As demonstrated through their prison records, both Erik and Lyle present as individuals who are not likely to commit any new offenses, much less a super strike, and are ready to re enter society. The underlying goals of accountability, retribution, and rehabilitation for both Erik and Lyle have been achieved. They have used their time of incarceration well and now show that they are not a risk to public safety. Erik and Lyle both deserve a lesser sentence. For all the reasons articulated above, the people believe it is in the best interest of justice to resentence Erik and Lyle Menendez to a sentence that aligns with their best levels of rehabilitation. I kind of get chills reading that because I've been waiting for this for a while, as I'm sure a lot of you have. Therefore, the people asked the court to recall Erik and Lyle's sentences and resentence each of them to a new term of 50 years to life, as described below. The imposition of a new sentence will allow the defendants to go through the parole process. Effective January 1st, 2014, Penal Code Section 3051 created a youth offender parole hearing process that will apply to both Erik and Lyle Menendez if they are resentenced to a sentence other than life without the possibility of parole. A youth offender parole hearing is a hearing by the Board of Parole Hearings for the purpose of reviewing the parole sustainability of any prisoner who was 25 years, they said 26 before, 25 years of age or younger at the time of the controlling offense. Pursuant to the statute, a person who was convicted of a controlling offense that was committed when the person was 25 years of age or younger and for which the sentence is a life term of 25 years to life shall be eligible for release on parole at a youth offender parole hearing during the person's 25th year of incarceration. Well, let's see. They've gone 35 years, so I think they're ready for a parole hearing. So they will be immediately eligible for parole, technically. So the young parole eligible or the youth parole eligible date for a person eligible for a youth offender parole hearing under this paragraph shall be the first day of the person's 25th year of incarceration. Well, it's past that, so they just need to schedule it now. So at the parole hearing, it is statutorily mandated that in assessing growth and maturity, psychological evaluations and risk assessment instruments, if used by the board, shall be administered by licensed psychologists employed by the board and shall take into consideration the diminished culpability of youth as compared to that of adults and hallmark features of youth and any subsequent growth and increased maturity of the individual. Family members, friends, school personnel, faith leaders, and representatives from community based organizations with knowledge about the individual before the crime or the individual's growth and maturity since the time of the crime may submit statements for review by the board. The youthful offender parole hearing process is not available to inmates serving sentences of life without the possibility of parole, which is why neither of the defendants has been able to previously seek this opportunity. Wherefore, people respectfully request that the court resentence Lyle and Erik pursuant to Penal Code as follows. Resentence Erik, first degree homicide 25 to life in state prison. Count 2, first degree homicide, same thing, consecutive, which means they can do it at the same time. Yes, okay. Total sentence 50 years to life in state prison. Same thing for Lyle. Signed, George Gascon, District Attorney, and Brock Lunsford, Assistant Head Deputy. Ooh, that's a lot, but very good information. I thought that was excellent going through that and kind of reading through what the next steps are and the recommendations for Erik and Lyle Menendez regarding possibly being paroled, which I really hope happens soon, especially for Thanksgiving, as the family would like. That would be great. But that's really coming up soon. So I don't know if it's going to happen that soon, but I would hope that, you know, people can work fast to make it happen before the holidays. We'll see. Do you guys think they'll be up before the holidays? Let me know in the comments below, and I will see you guys. Don't forget, Tuesdays and Thursdays, we stream the trial. We are on the closing arguments, so this is a special Monday episode for you guys. And Tuesday, tomorrow, you will see the next part, which is Lyle part 3 of the final part of his um, closing arguments for Lyle. So I'll see you guys then. Thank you so much for watching. Take care. Bye now.